SJC-12621, Board of Higher Education v. Commonwealth Employment Relations Board.
Mr. Cox, good morning.
Good morning, Your Honor. May it please the Court, my name is James Cox. I'm representing the Appellant Board of Higher Education today. The Appellant BHE seeks to overturn the decision of the Commonwealth Employee Relations Board. General Law Chapter 15A establishes and sets goals for the system of public higher education in Massachusetts. Section 22 of the statute empowers the boards of trustees of the state colleges to appoint, transfer, dismiss, promote, and award tenure to all personnel of the colleges. The SERB concluded a provision of the BHE's labor agreement that limits the appointment of part-time faculty to only 15% of the faculty in an academic department does not violate the non-delegability doctrine. That decision was an error of law.
Can you just explain, if you're saying that there's a problem with the provision, why did the board agree to it?
The board agreed to it in 1986.
But continued to?
And tried to remove it from the contract in 2007. The union refused. The board's agreement in 1986 was unlawful and improper. The board tried to remove it. The union disagreed, and then this litigation commenced in 2008, and it has taken us to today. But the contract provision's unlawful and improper and never should have been agreed to from the beginning.
That was the position of the attorney at the time as well, wasn't it?
He took that position in 2007.
2007.
The union disagreed, went to the presidents. There are 9 universities, each with a president. One of the presidents, just to maintain the peace, said, "Don't worry, we'll abide by the agreement."
So for 20 years, they thought it was, I guess, a permissive subject to bargaining or a mandatory subject to bargaining?
Well, surely in 2007 it was recognized that it wasn't. I don't know.
I understand in 2007, the economics have changed. There's more reliance on adjunct professors. But this impacts on the terms and conditions of employment of tenured faculty and regular faculty, right?
To a minor degree, it does.
Not to a minor, right? It
well-
depends on, if you don't have adjuncts, they're going to have to teach different classes, right?
Well, certainly in that sense, if there weren't adjuncts, and that was a decision that the provost made, excuse me, if there weren't adjuncts, we'd have tenure-track people teaching introductory level courses as opposed to courses that suit their specialties.
So you're saying there wouldn't even be an impact bargaining? There wouldn't?
Oh, no, I'm not. The decision to exercise that prerogative,
So it's subject to impact bargaining then, right?
yes, it is.
Okay, but it's not a permissive subject, even though it will alter how many classes they teach, how many people, which classes they'll teach, how many classes they'll teach?
No, how many classes they'll teach is a function of the labor agreement. That's set.
Well, but if you don't have adjuncts and the school needs more computer science classes, aren't they going to have to teach more classes?
Those are the factors that the provosts and the boards of trustees have to wrestle with.
Right, but if they don't have the adjuncts, that means they're going to have to turn to the regular faculty to do that, right?
Correct. Which, as the briefs detailed, might result in larger class sizes, a negative, fewer classes, also a negative, serving fewer people, a negative, and contrary to the goals of the legislature.
No,
in
I totally
15A.
get the impact on the university, but at the same time, if you don't have it, it impacts on the regular faculty. So that has impacts on terms and conditions. So doesn't that put you into the realm of permissive bargaining? And then every 3 years, you have to come to terms with it.
I would disagree, Your Honor, that it's a permissive topic. I think it's an unlawful topic because the bargain specifically compromised the statutory authority that the legislature vested in the boards of trustees of the state colleges, now state universities.
How does it do that? Because they have to spend more money? If they don't do it, I'm confused exactly.
Because the power to appoint is fundamental to the manner in which the institutions can provide educational opportunities. What the schools are after is a blend of full-timers and part-timers to meet the various needs. There are 4 identified in our brief that part-timers satisfy. But all of that is in service to a core curriculum that the institutions have concluded is essential if they're going to provide the best education that they can for the funds that they can. If I could distract us to a case that I came across.
Don't distract us yet. You can distract us in a moment. If you win, what would prevent the board from saying we're going to simply freeze the number of tenured faculty, and we're going to essentially have our state universities move to the ratio of adjunct to permanent faculty that apparently exists nationwide, according to the briefs, which is a 70%?
The boards of trustees and the Board of Higher Education is committed to providing the best education possible.
Try my question. I understand that, but what would prevent, is there anything, if you win, isn't it true that you could essentially say we're not going to hire any more full-time faculty? We're going to essentially have university students educated almost entirely by adjuncts because they're cheaper, and we don't need to pay health insurance.
It's the commitment of the Board of Higher Education and the trustees to providing the best education that would prevent that. And it is their judgment to make, not this court's, not the SERB's, the best way to provide an education. That power was vested by the legislature in the boards of trustees.
Well, doesn't the School Committee of Newton case stand for the proposition that even a non-delegable decision can be bargained?
A procedure concerning a non-delegable decision could be bargained, and 150 Section 6, in terms of school committees, did give, it made workload and class sizes a bargainable topic. That's not the case with higher ed. Let me bring your attention briefly to a case that wasn't in the briefs, and I apologize for this. I found the case 2 weeks ago. It's an SJC case, Local 589, Amalgamated Transit Workers v. MBTA. The site is 392 Mass 407. It's a 1984 case. I think it's very pertinent to this. The statute at issue there was General Laws, Chapter 161A, Section 19, which the legislature identified the inherent managerial authorities of the MBTA. 2 years after the statute was enacted, and two of those authorities, by the way, were the authority to direct, appoint, and employ, and also the power to hire part-time employees. 2 years after the statute was enacted, an interest arbitrator rendered an award. The award contained the identical limitation upon the employment of part-timers that is at work in this case, a 15% cap of the part-timers in an employment classification. The T sought to vacate the award, and it came to this court. This court concluded that the plain meaning of the power to hire part-time employees was defeated by an indirect restriction upon the numbers that could be hired. That is exactly the situation that the Board of Higher Ed is dealing with.
So why did we decide the substitute teacher case the opposite way then?
The substitute teacher case, I think, is very different because that very directly impacts upon bargainable topics that are also terms and conditions of employment. I mean, there's no doubt that...
But this don't all of these cases do both? There's both, whenever you bargain something, you give away some of your inherent power. But almost all these cases involve this blend, don't they? Where you give up something because it relates to terms and conditions. And our cases don't provide sort of clear guidelines on where that line is, do they?
I can't disagree with you, Your Honor, that your job is to draw that line between what's delegable and non-delegable.
But like in the substitute teacher case, it seems like the same issue. There's a demand for substitute teachers.
Well, in that case, there are a couple of issues. First off, the topics were bargainable. Class size and workload were both bargainable in that case. In addition,
So isn't this bargainable too?
I argue it is not, Your Honor, that the power to appoint that was granted by the legislature should not have been sacrificed by the BHE.
They're not, by interfering with whether it's a full-time or a adjunct, the school gets to hire both categories, right? They make all those appointments.
The schools make the appointment until it gets time that, well, we can't appoint the next part-timer because we've got too many full-timers, or we don't have enough full-timers, rather.
But no one at any of these colleges will be appointed by anyone but the college, right?
That's correct.
Unlike the case, the Roxbury Community College case, where actually the arbitrator took over the appointment power,
Well,
right?
he tried, and of course, this court concluded that Section 22 the power to appoint was non-delegable, and an arbitrator could not order that an individual be
There,
appointed.
that person would be in the mathematics department indefinitely, right?
In theory, correct.
And here, in 3 years from now, is there anything preventing the college from saying, okay, now we're done with this? The economics have changed, we need more adjuncts. Why aren't you left to a 3-year time frame, except for on things that are clearly, essential
We have,
university fund, like that? You can't say, okay, the union doesn't get to decide whether you're going to teach history or computer science, but they get to do this kind of thing.
the colleges have agreed that a tenured faculty member cannot be removed absent a certain procedure. So that could not happen. The schools are primarily staffed by tenured faculty, and that is the single largest expense of the schools, are the salary of
But in
tenured
3
faculty.
years from now, the colleges will say, okay, the economics have changed, we can't have this anymore, because it's now interfering with our ability to run the university system properly. Right? They can do that. 3 years from now, right? 3 years from the beginning of the contract, it's over, right?
3 years from now, the schools can employ more part-timers after this decision is rendered, if it's in the favor of the Board of Higher
But
Ed.
3 years from now, when they negotiate, it's a 3-year collective bargaining agreement, right?
That's correct. That's
So at the end of that 3-year term, what's to prevent them saying, okay, now the economics have changed. We can't do it anymore.
Their commitment to providing the best education
But
possible.
that answer, I understand that everybody's committed to education and has the best of intentions with regard to this, but the pressure that's placed on that decision that this contract puts on the decision-making process, that pressure can be alleviated. All Justice Kafka is saying is that in 3 years, you can bargain this provision away.
The 15% provision could be bargained away,
Yes.
correct. Correct, it could be.
Which is what sort of bothers me, going back to Justice Budd's initial question. It could be, and in 2007, it wasn't.
It wasn't because the union refused. What has happened is the power to appoint has now become something that has to be negotiated with the union. What the legislature intended to be the authority of a board of trustees, it's now up to a consensus with the union, 15%, 20%, with no regard to the other needs of the institution.
Isn't this part of
and
the
their merit.
bargaining process? Isn't this part of the bargaining process, though? How is it that the board can agree to a provision, because you say the other side would not agree otherwise, knowing that you're not going to be able to meet it? Isn't that bargaining in bad faith?
It's a difficult context because the bargain over this topic was unlawful in the first place. So how do you best conduct unlawful bargaining? My argument is that you don't at all. And this court has a number of times had to address that, where institutions, I'm thinking of the Boston Police one-man car case. In that case, the contract said there'll be 2 officers in a police car. That provision ran afoul of the police commissioner's statutory authority, and in 1989, the court concluded, no, that you can't do that. I don't care that they gave that away. The police commissioner has the authority to decide how many people to put in a car.
I mean, what troubles me is what you've heard troubles my other colleagues. In 2007, you could have negotiated or said, okay, why don't we have adjuncts teach? The real issue, as I gather, is the teaching of the freshman year English composition classes. There's basically the expository writing, because you need small classes, because you need to be reviewing the written work and you need to be providing comments, and that provides a substantial burden. You could have negotiated that we're going to exclude that from the category of faculty and said that's to be adjunct. That's what happens in negotiations. So you're asking us to essentially give you the ability to essentially transform the state university system into a nearly total adjunct. We just have to wait for the current tenured faculty to die. And then we can go to an entirely adjunct faculty, and we're relying entirely upon your claim that the Board of Higher Education is going to act in the best interest of all, and that the interest of faculty can be pushed aside.
Respectfully, neither CERB nor the court is the Board of Higher Education, which is the entity that has that authority over the best manner of providing education. 15A is about providing an education to as many in the populace as possibly can with the resources that the legislature and student fees allow.
I totally agree with that, but in 2007, You could have fought this. If it were that important, you could have said, we're not going to, this interferes with the way we're going to run the university. We're not going to agree to this. But you didn't. You decided you could live with it, right? Even the head of the university said, right?
You're right, Your Honor.
So why should we decide that it wasn't important enough for you to bargain to impasse over that, given that you'd had it in place at that point for 21 years, right?
I
And then
understand you,
now-
but I have
now
to
we-
disagree with your conclusion that it wasn't important enough, but what was
Oh,
important.
but it wasn't important enough for 21 years to pick a fight.
Well,
And then it wasn't
picking
even.
the fight is, I apologize.
Go
for
ahead, no,
interrupting.
interrupt.
The disruption that occurs on campus when a contract is being negotiated influences the presidents. They're about the job of educating, not having students riled up and faculty demonstrating and everything else that accompanies labor relations in a contested
Being a
contract.
university president is no bargain, I get that. But that's not the issue. The issue is you didn't feel like it was worth that fight then. It wasn't necessary. And actually, you said we're going to comply with it. It just seems like you can't do it now. You can do it at the end of the term. I completely agree.
Well, you're suggesting that there be an estoppel that would prevent us from doing it now.
Well, no, I mean, the cases, I can see where you're entering into some kind of agreement that, particularly those that last such a long time, like the appointment of a tenured faculty member, that goes on forever. But it just seems like this is within that gray area that's a permissive subject of bargaining, that you have to fight it out every 3 years. But go ahead. You know.
Well, with the MBTA case, it wasn't gray at all to this court, and admittedly, that statute was slightly more specific, but only slightly. The legislature here gave the power to appoint, dismiss, promote, grant tenure. There's nothing left when it comes to administering faculty than what the legislature listed. I argue that the entire panoply of employment authorities was granted to the boards of trustees.
But don't you agree that the conditions of employment of full-time faculty are affected by the percentage of adjunct faculty?
I think there's
Committees, for instance, committee chairs and filling committees?
There's an indirect impact. Part-timers don't serve on committees. By the way, part-timers are represented by the same union that represents full-timers. Part-timers could negotiate their way onto those committees if they wish to, but they aren't there. Department chairs who supervise part-timers are compensated greater if they have a lot of part-timers in their department. They get more release time to do the work associated with them. Full-timers get the benefit of teaching the upper-level courses consistent with their specialty instead of teaching lower-level introductory courses. In English, again, English department faculty focus primarily on literature. They're not writing teachers or rhetoric teachers, which is why part-timers are especially essential in service to the core, and that's true in other disciplines.
Okay, but I'll ask my question again. Does it not affect the conditions of employment of full-time faculty?
If there's an impact on those conditions, the school's obligated to bargain over it.
Okay, but doesn't inherently the percentage of adjunct have an effect on the conditions of employment in that adjunct faculty generally are not there to confer with students? They're not generally a part of student life because they have other jobs?
Those aren't part of the job description of adjuncts that have been negotiated for adjuncts. Although they confer.
How about for full-time faculty? Don't they have obligations to spend time with students and to be engaged in student activities and to be engaged in committee assignments and to be involved in other obligations apart simply from their teaching and research?
That is all true, Your Honor. Scholarship, contributions to the school, academic advising is a function of full-timers. Part-timers advise students in their classes only, but they don't serve a major because they're not an aspect of the department in that way. For instance, full-timers will advise majors, part-timers advise students in their classes.
I expect we'll hear from the union that the repudiation here was deliberate and that the amount of adjuncts have grown over time. Should they make that argument, what would your response be?
I would argue first that, and there's evidence in the record from one of the provosts, that given the choice of not offering a section or canceling a course because they didn't have a full-time teacher, she would assign a part-timer to it knowing that it pushed her over the cap. I don't think there's any refuting that. And I've already forgotten the second part of your question, Your Honor. I'm sorry.
No, it's just the implications if the repudiation was deliberate.
We didn't argue repudiation in our brief, and we're not arguing at that finding now.
So I have one final question. You've been referring to the local 589 case?
Yes, Your Honor.
Now, that's based on a specific statute.
Correct.
Do you have an equivalent statute?
I've cited the statute, appoint, dismiss, promote, grant tenure
Okay.
is our
that
statute.
similar?
Their statute was direct, appoint, employ, and hire part-time.
Okay, but the statute in the MBTA case will be similar to your statute?
Statute in the NBA case is much longer and more detailed in how it described the managerial authorities. 15A22 is much more detailed than Chapter 71, where a lot of the K through 12 cases have come from. But you'll still see the word appoint in 161A as well as 15A22.
Thank you.
Apart from the case which you haven't cited until now, do we have any cases in which the non-delegable power of appointment has affected anything other than the ability to determine who they hire?
Not Section 22, no. The cases in the appeals court and this court have only been about an individual being appointed.
So if we do this, where does that lead us to?
If you do this, you acknowledge that a board of trustees can create a blend, and that blend can include the manner in which individuals are employed, part-time as well as full-time. The schools still retain authority over each individual who's an element of that blend, but you acknowledge that part-timers as a class are within the discretion of the boards of trustees. And in closing, because I see all these red lights, the legislature created 15A and directed the schools to serve as many of the Commonwealth students as possible. And these are the Commonwealth's neediest students that go to the state universities and the community college. And if it weren't for these schools, they might not have an opportunity for a college degree. Any limitation upon hiring frustrates the board in delivering their services. These are boards of small schools. They need to be nimble. They have to react to student interests, changes in curriculum, regional needs, demographics, and the board shouldn't be straitjacketed by artificial limits upon how they can appoint. The students deserve more.
Okay, thank you.
Thank you.
Ms. Gabriel?
Good morning. Jane Gabriel on behalf of the Commonwealth Employment Relations Board, which I will refer to at the best of my ability to the SERB throughout this argument. What the Board of Higher Ed is asking the court to do is to grant it one of two types of authority: a specific grant of authority, a specific statutory grant of authority, or a general grant of authority subject to the non-delegability doctrine taking this provision outside the realm of bargaining. The board cites the MBTA case, which is a very specific statute, which, to Your Honor's question, is very different than the Chapter 15A and Chapter 71, which is the school committee statute, in that it specifically lists what's taken out of the management prerogative. It specifically lists appointment of part-timers. And I'd note that the MBTA isn't subject to Chapter 150E, so it's an entirely different animal than Chapter 15A. The other reason that this isn't a specific statutory grant of authority is this court has consistently looked at Chapter 15A in conjunction with Chapter 71, the school committee statute, and consistently found that this is a general grant of authority to the Board of Higher Ed, subject to the non-delegability clause, and which comes hand in hand with the ability for the employer to bind itself to procedures to implement the policies that they decide that are non-delegable.
This is a major interference with how they're going to be able to run the university. I'm not saying it's beyond the power to bargain, but this changes, how many, people are going to be taught introductory English. If you need computer science professors, this may prevent you from bringing in computer science. This is a big restriction on their ability to handle the present needs of students, isn't it?
Your Honor,
It's
that's what-
fairly enormous.
That's what the Board of Higher Ed has argued,
Well,
but
it's not
in-
just the board. I mean, all you have to do is sort of monitor the way universities are working these days. This is a big change. This is a big restriction. That's why it's becoming such a huge issue, right?
Well, Your Honor, there was a reason, if I could answer that in terms of whether or not it's a big change, there was a reason that they negotiated this, and I don't have the bargaining history, but in 1986. So the issue existed in 1986.
The issue, yeah, but no one was really too worried about it because the model for education is changing. One of the things we say in I think it's one of the 370 mass cases is, if you need to be able to make policy changes and live within budgetary constraints, right? If something rises to the level where it's interfering with the way you're running the university and creating a huge budget impact, that starts getting into non-delegable.
Your Honor, it goes back to what the SERB considered.
Could you put the microphone a little lower so we can hear you a little
It
better?
goes back to, is that better?
Yes.
It goes back to what the SERB considered when they were making their decision. First and foremost, the Board of Higher Ed exercises its managerial authority when it decides how many students to admit, how many courses to teach, what the curriculum will be. That's what's granted to them in the statute.
How many people need to have a small English class because otherwise our students aren't going to be able to write?
I understand.
How many, we don't need French professors. Being a child of a French professor, I'm not saying there's anything wrong with that, but we need computer science teachers, and we need lots of them because that's all the students want, a computer science degree. They're not going to be able to react very quickly with this restriction, right?
Well, as a practical matter, the board's own witnesses testified, and Dr. Ashley put in her grievance decision that there were options. They don't have to affect those things. They could hire temporary full-time professors. They could do other things. I mean, there was a lot of testimony pointed out in the brief, in the SERB's brief. And there's also a very important fail-safe clause in Section C10, which is the provision we're talking about. The fail-safe clause, which the SERB recognized,
Well, I'm
makes-
confused that they can hire temporary full-time, but not, meaning they can fill this by hiring temporary full-time but not adjuncts? Is that what you're saying?
Well, they have options to
ahead,
hiring
give
more
me-
than the 15% cap. I think some of those options were, by their own witnesses' testimony, were to hire temporary full-time faculty, were to alter and reduce course offerings. This is from their own witnesses.
Right, but
was to-
offering and reducing course offerings, again, we do this by department, right? Any department with 6 or more full-time members, right?
Correct, correct. And that actually makes it more manageable because it's from department to department. It's not this college-wide hamstringing. It's
But
from
so
department to
if the-
department and makes it much more
But
manageable.
I'm confused. If the university says, okay, I want an introductory English class with no more than 10 people, how do they do that? So how would they address that? Give me 2 examples. How would they address that problem? And how would they address the problem of, we have 800 students signing up for computer science now, and we didn't have anything like that problem before. So how do they do that with this agreement?
So when they choose to admit the students and they exercise their ability and they decide that those are the course offerings, they can hire temporary part-time faculty to teach those courses,
I'm sorry,
which aren't
temporary
tenured
part-time or temporary
faculty.
full-time?
Temporary full-time faculty is a terminal, is that what I said?
You said part-time faculty.
I'm sorry, temporary full-time faculty. And
So,
if,
what temporary, just explain, I'm familiar with adjuncts, I'm familiar with tenured professors and associate professors and assistant professors. A temporary full-time faculty member is what?
Your Honor, I don't want to make it up, but my understanding from the record, because this is not my expertise, but I believe it's a non-benefited. They're
it's a
junior professors that aren't paid at the same level as the tenured professors.
Do they get health care? I'm confused.
I don't know. I don't
But-
know the
So,
answers.
because that's important, because, I mean, the adjunct, the reason they're relying on the adjunct is they cost no money and they have no health care.
That's correct, Your Honor.
Are we just creating a new kind of adjunct in your category? I just don't know what that is.
Your Honor, the best I can tell you is that it was the experts that recommended that as a solution to the problem. So do I know if it's another kind of adjunct?
The experts, whose experts?
That was Dr. Ashley, who made that recommendation in her grievance decision. So Dr. Ashley is the chair of the Council of Presidents, and she's the one that decided the grievance decision. And in
Where
the
is that in the
grievance-
record? Do you have the site to that?
The site in the record to the page
Is it
number?
in your brief at least?
It's actually, it's in the brief, it's actually quoted in the board's decision.
Okay, we can find it, sorry, I didn't mean to
Do you want me to
distract you.
find it, Your
No,
Honor?
I didn't mean to distract
I
you,
mean,
go
the
ahead.
language from Dr. Ashley's grievance decision is quoted, and Dr. Ashley specifically acknowledges, look, we've not been in compliance, we need to do something about this, and she offers ways to do that. Subsequently, the president of another school, Dr. Antonucci, adopts those recommendations and says, yes, we have to follow Dr. Ashley's grievance decision, we're not in compliance, and so these again were recommendations for solutions and ways that the caps did not need to be exceeded. And in addition, in the SERB's brief, there are many cites to testimony from the witnesses, from the Board of Higher Ed's witnesses, which offer solutions. Solutions so that they didn't have to break the caps.
Well, I mean,
And those, I'm sorry.
You had mentioned the word fail-safe, but you didn't explain what the so-called fail-safe alternatives are.
So there's a final paragraph in section C10, which is a fail-safe clause, which allows appointment of adjuncts in excess of the 15% cap in several circumstances, including any unforeseen emergency. It also includes sabbaticals, unpaid leaves of absence, reduction of teaching loads for purposes of alternative professional responsibilities. That's the last paragraph, Your Honor, in the in section C10, and why that's distinguished from
Isn't that
the first
emergency-
paragraph,
isn't the
which
emergency-
imposes the. I'm sorry.
Is the emergency defined more particularly somewhere? I thought it
Not
was
that
like when a professor gets sick or something to that effect.
No, which actually makes this user-friendly, because unforeseen emergencies, allows some discretion to the colleges. And there's nowhere in the record where I've seen that the Board of Higher Ed has invoked that, invoked that as an excuse for exceeding the caps. What the caps do is they control the number of adjuncts, the percentage of adjuncts that can teach depending upon the number of 3-credit courses in foreseen circumstances when the Board of Higher Ed has decided how many courses they're going to teach, how many students they're going to enroll, and exercised all of the management authority that they've been granted. So there is some room. And the other thing is that there are 2 schools that are in compliance. I think it's Fitchburg State and Mass College of Art. So it can be done.
It wasn't, and they negotiated a higher percentage in
It's
anticipation.
20% for the Mass College of Art.
Anticipated, I imagine, because of the nature of the classes, that they needed to negotiate a higher percentage.
That may be the case, Your Honor, but Fitchburg State was also in compliance with the caps. And again, this comes from their witnesses.
Where do graduate students teach sections in the state universities?
Your Honor, that's not in the record.
So is there anything in the record as to the role, if any, of PhD students or whatever else in terms of teaching?
That's not in the record that I'm aware of, Your Honor.
With regard to I think we probably would want to know, with regard to the temporary, I assume these are contract professors, essentially? They're temporary, you provide a contract for 1 or 2 years for them. I would think they would get health care benefits, would they not? I mean, we should know that.
But even if they do, Your Honor, and I don't know that the record describes what it may, and I apologize.
Okay,
But
you can, I think we'd like a 16L letter as to what the payment structure is for temporary full-time faculty, if you can find from the record if there's any guidance as to that.
yes, Your Honor, I will do that.
Is Dr. Ashley's decision in the record? I see your references in your decision. Do we have Dr. Ashley's grievance decision in the record as well?
Yes.
Okay, good.
So if the university says we now want every freshman to take a 15 or 10-person writing course, your view is that they should hire temporary writing professors?
Your Honor, I'm reiterating some of the suggestions. There were other suggestions to have, and as much as there's an objection to it, have the full-time professors teach the courses.
Well, of course, if they do that, then they're not teaching the higher level, more sophisticated courses. I mean, there's a
No,
cost
Your Honor,
there.
they're not. But again, they're witnesses who are, who were professors.
So the union wouldn't grieve
Suggested that
that?
as a solution.
The union wouldn't grieve that? That wouldn't be a violation of the collective bargaining agreement itself?
And the Board of Higher Ed points that out, Your Honor, in their brief, but
So
these
you've
are-
got
these
Shakespeare
could-
scholars now teaching Intro 1. They're not going to grieve that?
They could negotiate it, Your Honor.
Mm-hmm.
I mean, like anything else, they could negotiate. They could have negotiated this.
If the percentage of adjunct professors, if that's a non-delegable authority, do you agree with Mr. Cox that the school committee of Newton has no application to the situation, or may the board nonetheless negotiate that percentage?
If it's non-delegable, it's non-delegable, but the Newton case absolutely applies, because the Newton case is a case, one of the many cases that points out that you can bind yourself to procedures in the contract to implement your policy, and this looks like a procedure. I mean,
Really? This looks like a procedure? It's a substantive rule. 15% is a cap. That's not a procedure.
well, Your Honor,
A procedure is, if we hire adjuncts, we'll discuss this with the faculty members, but this is a substantive rule. I'm not sure it's barred, but it's not procedural, is it? How is it procedural? I don't see the process involved.
It seems to me that fundamentally, when you use 15% or percentages in implementing something, that's more of a procedure. And I don't like to use analogies, but
So if I give the faculty members a 15% raise, is that a procedure, or is that substance?
if the Board of Higher Ed if it's in the managerial authority to determine raises, and then you negotiate with the union that those raises will be at a 10% increment, a 15% increment, then that's a procedure.
The amount itself and how it's done is a procedure?
Well, I think that a lot of the contracts,
Give me an example of
I
a
think that-
procedure like that in the cases?
a lot of the contracts that we
In
see
the cases?
in the
Any case that defines that as a procedure?
Your Honor, I don't have a case. What I have is examples and contracts of step increases.
Oh, I know that the
and-
steps are common. So are percentages, but they're substantive rules. They're not procedures.
Well, I think there are lots of things that the court has defined as procedures that are more analogous to this 15% cap. There are procedures for discipline procedures.
That's a process. That's exactly what a process is.
Timing of layoffs, Your Honor, that's a procedure that looks, that's something that's negotiable, that do you decide you're going to do layoffs, but you have timing of layoffs, similar to in the Newton case. There are posting requirements. The courts recognize, appointment and reappointment criteria for teachers, criteria for tenure. Those are procedures, and I think that they are similar. I'd suggest to the court that they are similar to the 15% cap. And if that answers the court's question.
I don't think there are any cases that say those are procedures, but if there are, I'll find them when I look
Well,
through
Your
your
Honor,
brief.
actually, and I can't give you the case sites, but they're in the brief.
I've read the cases in the brief. I know we use the word procedures, but we don't seem to define what a procedure is and what substance is very carefully, or at all.
Well, I think that that goes to the court's very specific direction to the SERB, which the SERB did, was you have to do this, that you have told the SERB that they need to do a case-by-case analysis, and that it's a very nuanced analysis, and that's what the SERB did when it considered all of the factors that I was discussing earlier.
Can I ask a question that does not go to the merits? 2007, they effectively repudiated. Takes till 2015 for SERB to adjudicate it, and now it's 2019, and we are hearing it.
That's
For a
correct,
matter
Your Honor.
of this consequence, why is this so Dickensian in its speed?
Your Honor, the Department of Labor Relations in 2007 underwent a reorganization. They also went a long time without a chief counsel. And so the chief counsel, that's me, is the only one that handles appeals. And people in my office are here, and I know they don't want to hear this again, but I've disposed of 77 appeals in 6 years. I haven't written briefs in 77 appeals, but I've been working hard. We now have some, the cases get old, and if the court would like to give us a plug, we'd love a deputy chief counsel.
We don't get,
I think the
we don't get to a
executive
point,
controls
right?
the purse, but you can say that you were asked
Thank you, Your Honor.
as to why this process takes 12 years from the time in which the issue was ripe, essentially.
Thank
So,
you, Your Honor.
without further questions, thank you.
May I just, if I may, just ask the court to indulge me? I mean, the court in a recent City of Boston case, I mean, I know you know, the chokehold case recognized that there's a danger in granting a broad general grant of management authority in how it relates to Chapter 150E. If the court changes, diverts from the current rule, there's a lot more at stake than this provision and other protections for workload, for protecting workload, and for protecting other terms and conditions. And thank you for bearing with me in that last minute.
All right, thank you. Ms. Houle?
Good morning, Your Honors. Lori Houle for the Massachusetts State College Association. I'd like to go back to sort of where we were a bit ago in the arguments and point out that I think that this court has really hit the nail on the head. The real issue here is not about appointment authority or even the educational policy underlying the use of part-time faculty, but instead it goes to the financial implications of Section C10. This is, you know, we sort of probably inartfully call things procedures in a very general manner when we read the cases, when we're arguing these cases. But the cases are very clear. If you look at City of Lynn, they're talking about ancillary matters that go along with negotiating. So that might be procedures, it might be means of implementing decisions, it might be impacts of those decisions. And certainly this provision, I think, probably fits into all those categories. The board or their college administrations made certain decisions in terms of the classes that they need, the courses they're going to teach. And this is a means of staffing those in some ways. It certainly, as Justice Kafker noted, has an impact on workload of full-time faculty. It has an impact on work-life quality for them. Certainly, higher levels of full-time opportunities is beneficial even for the part-time faculty, who, yes, we do represent, because everybody wants to move towards having, you know, a potential full-time benefited job and hopefully getting on that tenure track.
Do you know what a temporary full-time faculty member is? Can you help us out with that?
So it's defined actually within the Article 20, where this section C10 is, in Section 6 defines hiring temporary full-time faculty. I don't think it references what their pay or benefits are. That's probably other places within the contract, and I would be happy to work with Attorney Gabriel in making sure we get you that information. But
A temporary full-time faculty member is not when the university brings in somebody, you know, from another college to give them a tryout or something like that. That's not what we're talking about.
I don't believe so. There's usually limits in terms of the number of classes that continue, number, actually, I think more specifically, number of semesters in a row. There's a whole procedure
And they're
within Article 20.
those people are in the union, and the adjunct faculty are excluded from the union, right?
Part-time faculty are also represented by the MSCA under this contract.
So an adjunct professor is is in the union or outside of the union?
There's procedures within the contract that says after a certain amount of time, and I don't recall what exactly it is, they have to teach like so many courses consecutively over so many semesters, and at that point in time, then they become a member of the bargaining unit. That is correct. And I don't think anybody on any side of the V here would dispute that, in an ideal world, having a higher number of full-time faculty is beneficial to higher education. The board here claims, without providing any evidence, as was pointed out by the SERB in its brief, that this cap on the ratio, it's not a hard number. It's not like only 15% of the total number of part-time to full-time has to be,
Sounds
can't
pretty,
be, but
sounds
it's
pretty
a
hard.
ratio.
Sounds pretty hard number.
Well, you could have, the board can make the decision to say there's 5 courses that need to be taught, and they could hire 5 different part-time faculty to teach those 5 classes, or they could just have
No,
one
they
person
can't.
teach
They
those 5
can't
courses.
unless they have the right ratio of full-time. They can't just, that's the problem for them. If it were that easy, it wouldn't be it's a real, it's a real constraint.
You are absolutely right. These are challenging issues that any employer has to face. It's not just a matter, say, for, it could be analogized to like a contracting out provision, a job security provision in the other BTU case, right? That's certainly going to impact an employer's ability in terms of managing these different tensions, as this court has recognized, that come up when you are engaged in bargaining. But the legislature has struck that balance. The legislature has said, we have a public policy promoting collective bargaining. We also have policy that's engendered in the different cases, the enabling statutes for the different entities. And where it draws that line in terms of delegability varies depending on the entity involved. So, for example, the MBTA has, which is not a 150E, doesn't even fall under this. They created its own collective bargaining statute, basically in 161A. They were very explicit in terms of defining those inherent management rights. And even in like the police cases where you have public safety issues, they were very explicit. This statute is not that. This statute is very general. It's like Chapter 71. You could look at, say, the CJAMS cases, the Chief Justice of the Trial Management of the case, where they distinguished between temporary and permanent appointments for stenographers. And because temporary was, I forget which way it was, but one of them, temporary, was actually explicitly listed in the statute. They had absolute managerial control over that. But because permanent wasn't addressed, they said, well, then that could be bargained. Same with the School Committee of Pittsfield case. You have principals that have the hiring authority, but it talks very specifically, they analogize filling a vacancy, like a voluntary transfer is like filling a vacancy. It's like a new hire, whereas an involuntary transfer is more of a means, just like this is, of determining the staffing needs of the district, and therefore that was subject to bargaining, and they could negotiate over the procedures and the means of implementation and the impact of that.
Let me follow up on that. I mean, I agree that the line is not precisely drawn, and that there is a matter of judgment on our part in terms of determining the board's ability to manage schools for the benefit of the children of the Commonwealth and the interest of faculty. To the extent that it is a matter of judgment, to what extent is that judgment appropriately affected by the conduct of the union with regard to its willingness to negotiate matters?
Well, I think you hit the nail on the head again. So this is a bargaining matter. They could have, in 2007, when, rather than repudiating, like coming to an agreement, negotiating the agreement, signing it, and then sending a letter that says, nope, we're not going to abide by that. They could have said no. They could have taken their stand at the bargaining table. And the union, yes, the union said, no, we like this provision. It helps protect our members. There's a process for that.
Well,
it's called
so
impasse.
What do you think of the Board of Higher Ed's answer to my question and Justice Budd's question about 2007? I think the answer was we had no choice.
No, they'd had a choice. They had a choice to take a stand at the bargaining table, and the parties would have reached impasse. Chapter 150E provides impasse procedures. They would have gone through that whole procedure, and then there would have been an outcome for that. And then another, just to sort of put out there.
So in your view, it's a mandatory subject of bargaining. It's not a permissive subject of bargaining.
Correct.
But if it were a permissive subject of bargaining, could they just unilaterally do it, or at least have just impact bargaining related to it? Say we decide that, okay, we agree with you that it's not a totally discretionary decision, but we also don't look at this as a mandatory subject of bargaining, but rather a permissive one. What would happen if you reached impasse on that?
So, I mean, certainly this court has not really reached the question of permissive bargaining, but in other, like NLRB or the FLRA, which is the federal statute, then once you come to an agreement on a permissive subject, then it is enforceable for the life and duration of that contract.
But my question is, when the contract ends, 3 years from now, although we're past 3 years, by the way, this isn't moot, right? This thing is,
It's still, in fact, the parties have
so they're
actually
negotiating,
negotiated.
are they negotiating this right now?
Yes, they actually
great.
had negotiated some changes to this provision. My understanding is some other institutions had tried to raise the cap. They were looking at it more on a college-wide level versus a department-by-department level. However, the government didn't fund this.
I just want to make sure I understand now. So that, the agreement that we're interpreting is expired. Has it been replaced by a new agreement?
No, currently the language stands.
So it is being bargained as we speak?
My understanding is that there were changes that were negotiated, the governor didn't fund the contract, so now they're back at the table. So, but to finish answering your question, in the permissive bargaining world, so once the contract ended, yes, then the management could say we're no longer going to abide by that.
Uses they'd have to do impact bargaining over that.
Absolutely.
Right.
Absolutely. And just to throw out there another thing, in addition to these impasse procedures, because we do believe this is a mandatory subject of bargaining, they could have gone through the impasse procedures, or if, say, in the middle of the contract, there were true economic exigencies, budgets just got blown up, something happened, just whatever it happens to be. Again, 150E and the Department of Labor Relations has procedures for that. In that circumstances, if it actually meets a true economic exigency, then the board could give notice to the union, they could engage in some expedited bargaining, and they could implement changes even in the middle of the life of the contract. Now, those are very narrow circumstances, but they certainly provide outlets for the concerns that I'm sure that the court is considering right now.
So when the statute refers to any unforeseen emergency, that's not a unilateral ability of the board to decide to change the percentage. Is a process to go through.
Correct. I think that what that means is that it is in the board's discretion, however, to determine an unforeseen emergency, to define what that unforeseen emergency was, which would then come under that sort of safety clause that the CERB noted.
Yeah, all right.
All right, thank you.
Thank you very much.